and welcome to Collier Bristow's Winter Financial Services Update. I'm Robin Henry. I'm the Head of Dispute Resolution here at Collier Bristow. And today, my colleagues in Dispute Resolution will be covering the following topics. First of all, Nichola Leach will be talking about private equity disputes. Jean-Martin Louw will be considering LIBOR transition, and Ryan Lynch will be talking about crypto fraud. There will be time, I hope, for a Q&A session at the end of the webinar for all three topics. And if during the course of the webinar you would like to ask a question, please do so by putting your question in the section marked Q&A at the bottom of your screen. Just to let you know that this webinar is being recorded, and the recording and the slides will be circulated after the webinar. And with that, I will hand over to our first speaker, which is Nichola.
Good morning, everyone, and thank you, Robin, for the introduction. As mentioned today, I will be looking at whether the increase in private equity activity, which has been experienced recently, will lead to a corresponding increase in private equity related disputes. I'll start by first summarising the high level of investment activity currently taking place in the industry, followed by why we believe there may be an impending increase in this type of litigation. And then I'll conclude by just looking at a few of the claims which may be brought. The post-COVID economic recovery has seen high levels of M&A activity in 2021. Private equity firms are keen and eager to deploy funds following a muted 2020. An August 2021 report from KPMG found that private equity investment in the UK has risen to its highest level in 5 years, with deal volume increasing by 61% in the first half of 2021 compared with the first half of 2020. The boost in activity is attributed to the post-COVID recovery, more foresight on Brexit, and anticipated changes to the capital gains tax regime that many expected to be implemented in the March 2021 spring budget. Investment has been particularly strong in the telecoms, media and technology sectors, as well as the healthcare services sectors. There's also an increased interest in companies with a strong ESG focus, with the same report finding that 45% of UK investors are looking to back green or sustainable companies in the next year. The fruits and financial success of this activity remains to be seen. However, as litigators, the question we're asking is why, or perhaps more how, could this flurry of activity lead to an increase in disputes in the private equity industry? Before looking at the potential reasons for these increase in disputes, I just wanted to touch on what is generally perceived as the norm for PE litigation. PE firms are generally seen as reluctant to pursue litigation. One reason for this being that it brings a dispute into public forum. It can carry reputational risks for all involved. It potentially impacts on a general partner's ability to raise the next fund, the limited partner's capacity to commit monies to other funds, and relationships with portfolio companies. For this reason, many disputes are likely to be behind closed doors and perhaps resolved through mediation or arbitration, which I'll touch on later. A second reason is the cost of bringing high court claims and the period taken to resolve them. It can often take 2 years to reach a full trial. In some instances, pursuing a claim following an investment which turns south can often be seen as basically throwing good money after bad and a diversion of resources. So what has changed which may make these disputes more likely? I think this question can probably be covered broadly from two angles. First, arguably the unique economic backdrop against which these investments have recently been made. There is general uncertainty in market conditions. However, PE firms are eager to deploy funds after a mooted 2020. There's also high competition for investments, given that many funds lagged behind with their deployment levels in 2020. With this in mind, investments may not have been completed to the same level of financial scrutiny that they would have been pre-COVID. Perhaps target companies are experiencing artificially high financial performance, supported by temporary changes in consumer demand during lockdown, and has financial performance been propped up through COVID support, such as furlough. These investments may go on to underperform, and PE firms need to find an alternative source of recourse to salvage their investments, and perhaps this may be in the form of litigation. Likewise, deals which completed shortly before the COVID outbreak may have had deferred consideration or earn-out clauses. These figures calculated by reference to financial measures such as revenue or EBITDA. These calculations may no longer be fit for purpose. Likewise, given investment pressures, has due diligence been undertaken with the same level of forensic detail that it normally would, particularly in a remote working environment? This can all make it transactions more risky. I think there's also two wider developments in the market which may make litigation a perhaps more attractive prospect for the private equity industry. And first, there's an increasing use of warranty and indemnity insurance and as an established feature of a deal. The insurance transfers the risk, or more specifically, the financial risk associated with a breach of warranty claim from the seller to the insurance market. A claim under an insurance policy could be seen as an easier route to secure recovery for a breach of warranty than a claim under the SPA. Without the insurance, a buyer may be reluctant to bring a claim for a breach of warranty against the seller, because often they're involved in long-term working business relationships with these individuals, and starting litigation doesn't exactly get this relationship off to the best foot. A second broad reason could be the litigation funding market. Litigation is an expensive exercise, but increasingly, I think private equity firms and their advisors are recognising the benefits of partnering with litigation funders who fund legal expenditure of bringing a claim in return for a slice of the rewards if it's successful. And both of these trends may serve to increase the attractiveness of litigation as a means of value recovery for a private equity firm if an investment does not succeed. So I'm now going to look at who may be the parties to these possible claims. And as I've identified on screen, they'll broadly fall into four categories. Claims between the limited partner and the general partner. The limited partner generally consists of pension funds and institutional accounts who commit capital to a fund. The general partner is the PE firm who manage the fund on the day-to-day basis, invest the fund and manage the portfolio of investments. Claims between the limited partner and the general partner of private equity funds are not generally common. However, economic uncertainty can cause significant losses to funds, and investors may need to look to recoup some of those losses, particularly where they believe the losses are linked to a breach of duty by the general partner. And the second category is claims under the warranty and indemnity insurance policy against the insurers. These can be brought either by the buyer or by the seller, depending who's taken the policy out. Normally, the policy provides cover for losses which arise from a breach of warranty or claims under a tax indemnity. And if it's expected that these claims may fall within the insurance coverage, a claim may be pursued under the policy. Claims between the buyer and their advisors. A transaction has many advisors, lawyers, accountants, commercial due diligence providers, tax advisors, and so on. The last 18 to 24 months has produced really unforeseen circumstances and highly pressured circumstances for remote deal doing. If a transaction goes wrong post-completion, and for some of the reasons identified previously, buyers don't want to pursue the sellers, then they may look to their advisors to compensate them for the losses. And the final category is a claim under the SPA brought by the buyer directly against the seller. And for the purpose of the remainder of this session, I will focus on this category of claims. So I think claims between a buyer and seller are likely to fall into two categories. Firstly, those relating to the price adjustment mechanism under the SPA, and secondly, those relating to the factual premise upon which the terms of the transaction take place. So addressing the first category, economic uncertainty could give rise to further claims relating to price adjustment mechanisms and the calculation of earnouts. Traditionally, a share purchase agreement provides for a completion purchase price to be varied after subsequent review. This is a process known as completion accounts, and it's done by reference to balance sheets metrics, most often the working capital and the net debt of the target as at completion. The impacts of COVID-19 may lead to significant differences between a seller and a buyer's estimations of these potential adjustments. Meanwhile, as I've mentioned, estimating the fair value of an earnout can be more contentious due to the unforeseen and temporary impacts from the pandemic. The second areas of claim between the buyer and the seller, as discussed, arise from the factual premise upon which a transaction takes place. These are likely to be either claims for a breach of warranty or misrepresentation. So if we take an example, a buyer agrees to buy the seller shares in ABC Limited for 20 million. The buyer has calculated the purchase price based on ABC's last audited accounts and certain financial representations made by the seller. The seller represents and warrants that the accounts show a true and fair value of the state of affairs limited of ABC Limited. If it later becomes evident that there were serious errors in the accounts, such as the shares are only now worth £10 million at completion, and the seller was aware of these errors at the relevant time, claims may be available in both breach of warranty and or misrepresentation. I will deal with claims under the warranties first. A warranty is a contractual assurance given by a seller to the buyer that a certain state of affairs exists at a given point in time. And these are documented in the share purchase agreement, the share sale and purchase agreement. Warranties can include general warranties about matters relating to the target company, financial warranties, tax warranties, environmental warranties. They're pretty extensive. An example may be that the seller gives a warranty that the target company is not engaged in any ongoing litigation or dispute. If it subsequently transpires that actually the seller has a high court claim which is ongoing and it is given an inaccurate and untrue warranty in this regard, the buyer may have a contractual claim for the breach of warranty against the seller. The usual contractual principles apply to a claim for a breach of warranty. The damages are intended to put the buyer in the same position that it would have been if the warranty had not been untrue. So in a share acquisition, the amount of damages will likely be the difference in the market value of the shares with and without the breach of warranty. So the example I gave in relation to ABC Limited, where 20 million was paid, but the warranty breach has been actually, it's only worth 10 million, the buyer may be entitled to claim the 10 million difference. There can be contractual hurdles to bring in a warranty claim in the SPA, which may exclude or limit the seller's liability. Examples of these include de minimis provisions. This involves setting a minimum value for a claim under the SPA. Maximum liability clauses. There will usually be a cap on the liability, which is often set at the purchase price. And where a warranty indemnity insurance is taken out, the SPA may actually include a provision which prevents the buyer from recovering against the seller where this insurance is in place. And finally, often there can be a contractual time limit on claims under the warranties. So therefore, certain circumstances, including the hurdles identified above, may mean that actually a an action and misrepresentation is the more preferred course, or actually it may be the only option available. So now we've got to look at misrepresentation claims. A claim for misrepresentation arises where a seller made an untrue statement of fact or opinion. This can be in writing or it can be oral, and it would have been made prior to the purchase of the business or the assets, and the buyer relied on this statement and it induced them to enter into the contract. So if we go back to the example of ABC Limited, a misrepresentation could be erroneous financial information being shared with the company prior to completion, which the buyer ultimately relied on. Just one key distinction to note is that warranties are contained in a contract, but a representation must occur before the contract was concluded. So importantly, sellers can find themselves potentially liable for statements they made prior to the deal even completing. Misrepresentations can be made in broadly three ways. They can be fraudulent, so that's where it was made knowingly without any belief in its truth. They can be made negligently, that's where it's made carelessly, or they can be made innocently. That's where it's made, but the seller can show they had reasonable grounds to believe in the truth of what they were saying. The threshold for pursuing a misrepresentation claim can be seen to be higher than that for a breach of warranty claim. And for the misrepresentation to succeed, the buyer must show that the representations were made before the contract was concluded. The seller making the statement in the case of a fraudulent misrepresentation knew that it was false, that the buyer relied on the statement, and that the buyer was therefore induced into the contract by this representation. So the remedies available in a misrepresentation claim depend on whether it was fraudulent, negligent, or innocent. I'll focus on fraudulent for the moment, because I think these are probably the ones which are most likely to occur in private equity related disputes. But the high level position is you can be entitled to damages and rescission. The measure of damages in a claim for misrepresentation is different to that in a breach of warranty claim. It will be the difference between the true value and the price paid. So essentially, this means putting the purchaser in the position it would have been had they not been induced by the representation to enter into the contract to purchase the company. So in my example of ABC Limited, the claim for misrepresentation could, in some circumstances, be as much as the purchase price paid for the shares, although the buyer would be expected to give credit for any benefit they'd received as a result of the transaction. And as mentioned, misrepresentation may also allow the buyer to unwind the contract, and they can also refuse to perform any future obligations, providing they haven't affirmed the contract. And they may also be able to claim for losses suffered because of the transaction. So as can be seen, a complaint based on the same facts can give rise to two very different financial outcomes if pursued, depending on whether it's done by a breach of warranty or a misrepresentation. So therefore, it's really important that early advice is taken on these types of claims when you think they may first occur. So I now just want to move on to a final point, which is to conclude this webinar, to touch very briefly on how these claims may be pursued, just keeping in mind the objectives outlined at the beginning to, recover any potential losses quickly and preserve reputations. So if you pursue a claim through the High Court, it can take 18 to 24 months to reach a conclusion, unless there's early settlement. And this isn't perhaps an attractive option to PE firms, where their primary objective is to realise a successful investment. It may be seen as a time and sink cost. However, there may be more palatable options available through arbitration or mediation. Arbitration clauses are provided for in some sale and share purchase agreements. And this is where a dispute is submitted by the agreement of the parties to an independent expert who'll make a binding decision on the dispute. This can have many attractive advantages. The parties have full control over the process, so you may get a resolution quicker. They are private compared with court proceedings, which are open, and the decision of the arbitrator is generally agreed to be final, and there's very limited grounds on which to challenge the decision. Now, of course, there can also be disadvantages, but I won't deal with that today. Another alternative is mediation, in which a neutral third party, the mediator, assists parties to work towards a negotiated settlement of their dispute. Mediation can take place either before or during the course of litigation. Discussions in mediation are expected to be confidential and without prejudice. This means they can't later be relied on in the proceedings if the mediation doesn't settle the matter. And for many companies looking to pursue these types of claims, perhaps holding a mediation before issuing a claim is a very sensible step to avoid parties becoming entrenched in their position and an escalation of costs. So the above outlines just some of the options available to the PE industry if they wish to pursue a claim, and the route taken obviously may depend on their ultimate objectives. So that's it from me, a whistle-stop tour of potential claims in the PE market and why we may expect to see more in the future. I look forward to taking questions after the presentations from Ryan and Jean, and I now hand over to Jean.
Thanks a lot, Nichola, and thanks again to everyone for joining us this morning. If I could get the first slide, please. Now, I'm sure everyone here is familiar with LIBOR as a concept because most financial instruments from the last 30-odd years with a variable interest rate will probably have been pegged to LIBOR, but it's there on the screen anyway. Essentially, it's the interest rate at which certain major banks lend to each other in the interbank market for short-term loans of varying lengths. And as we now know, it's a benchmark that was highly susceptible to being manipulated. So in 2017, after many, many scandals, the regulators agreed that LIBOR would cease at the end of this year with a transition to risk-free rates like SONIA in the UK and SOFR in the United States. And for the past couple of years, the FCA has been encouraging everyone with LIBOR-linked contracts to negotiate amendments so that those agreements don't become unworkable when LIBOR ceases. But as these things happen, lots of people drag their heels, and with certain agreements, there just is no realistic ability to renegotiate or amend the contract to reference an alternative benchmark. So the question is, what happens to those contracts that haven't transitioned off LIBOR by 31 December? And that's what I'm going to give you a bit of an overview about today, largely focusing on English contracts that reference sterling LIBOR. Next slide, please. A little bit of legislative background to start. So Article 23A of the new benchmark regulations gives the FCA power to prohibit the use of benchmarks such as LIBOR by regulated entities. And in March, the FCA confirmed that it would exercise that power with the effect that all 35 LIBOR settings will cease to be published on the dates that I put up on the screen there in front of you. So that means from 31 December this year, panel banks are going to stop making submissions for all LIBOR settings except the 5 US dollar settings mentioned in the second row there, the table, which will continue to be set in the sort of usual methodology until mid-2023. But I should point out that even though those settings will continue to be published, most new contracts written after the end of this year won't be permitted to use them. They're only there to be used in very limited circumstances, which we don't need to go into today. Next slide, please. Now, although the use of sterling LIBOR is going to be prohibited after 31 December, the FCA does have a power to exempt certain contracts from that general prohibition and to specify a different methodology by which LIBOR is to be calculated in those exempted agreements. And we've had some recent guidance from the FCA about which legacy contracts will be permitted to use that synthetic LIBOR and how it's going to be calculated. So first of all, it's been confirmed that all existing contracts that reference 1, 3, and 6 month sterling or yen LIBOR will be permitted to use the synthetically calculated rate, at least for the duration of 2022. The only exception to that is cleared derivatives, and that's because clearinghouses already plan to transition all cleared contracts to risk-free rates by the end of this year. And that sort of is a much broader category of permitted use than most people were expecting, because the FCA made some earlier comments that suggested synthetic LIBOR would be limited to certain categories of very tough legacy contracts where making the transition to a different rate would be almost impossible. But in the end, I think just because of the scale on which LIBOR is used in the industry and because lots of contracts lack proper fallback provisions to cope with situations where LIBOR ceases, they really just sort of were left without much choice. So, I mean, again, where we end up is that 1, 3, and 6 month synthetic sterling LIBOR will be published from the 1st of January next year for at least 12 months. And those rates are going to be available to use in all legacy contracts, but can't be used in any new contracts. And in terms of how long that's going to go on for, the FCA has sort of left the door open insofar as sterling settings are concerned. So we could see the synthetic rates continue to be published well into 2023, depending on how the transition process pans out next year. Get the next slide up. I'll just touch very briefly on the methodology for calculating synthetic LIBOR. For all settings, there's 2 components. There's a forward-looking term risk-free rate plus the ISDA credit adjustment spread for the relevant tenor. And in particular for sterling LIBOR, that's the ICE term SONIA reference rate, the TSRR, and that measures the expectation of what SONIA will be over the relevant forward-looking time period, so 1, 3, or 6 months, plus again the ISDA credit adjustments spread. And for anyone who isn't familiar with SONIA, it's an overnight rate. It's based on actual transactions, and it basically reflects the average interest rate that banks pay to borrow sterling LIBOR overnight from other financial institutions. And just very quickly, in terms of that ISDA adjustment spread, which is added on, these are amounts which have already been fixed earlier this year in March when the FCA announced that LIBOR would cease. I've just got them on screen there just for interest's sake. And these are calculated on a 5-year historical spread between LIBOR and SONIA. So just coming back to the legal side, when we say that the legacy contracts can use these synthetic rates, how the rate is actually incorporated into existing contracts is through Article 23FA of the Critical Benchmarks Bill, which hasn't been enacted yet, but it shortly will be. And basically that legislation says that any contractual reference to LIBOR in an exempt contract is to be treated as a reference to synthetic sterling LIBOR. So the definition of LIBOR is simply replaced by synthetic LIBOR within those legacy contracts. Next slide, please. So, I mean, of course, a lot of contracts already have fallbacks built into them, which lay out methodologies for calculating a replacement rate in situations where LIBOR is unavailable. So a lot of people are questioning, what synthetic LIBOR means for those fallback provisions. Are they triggered because ordinary LIBOR ceases on 31 December, or are they not triggered because we now have synthetic LIBOR still being published? And the answer is that it sort of depends on the wording of the fallback, specifically what the trigger event is for the fallback kicking in and what the intended effect of the fallback is. And generally speaking, fallbacks that try to change the definition of LIBOR in situations where the benchmark ceases, those ones might not be triggered while synthetic LIBOR continues to be published. But on the other hand, if the fallback operates to change the actual rate paid under the contract when LIBOR becomes unrepresentative, it will most likely be triggered. And I know that probably doesn't make much sense in the abstract, so we can have a look at how it works in the context of some standard market agreements. If we start by looking at derivatives, so I've got the key bits of the wording on screen there for the fallback language that ISDA provided earlier this year. And this automatically applies in all new swaps entered into after January 2021, and for anyone else who chose to amend the agreements voluntarily to incorporate that wording. So here, the fallback trigger is an index cessation event. And if you look at the definition of that term, we're not talking about a situation where LIBOR ceases to be published. It's defined as the making of an announcement that sterling LIBOR is unrepresentative, which already happened in March when the FCA announced it. So that is going to be triggered. And the fallback then specifies a different rate that's going to apply under the contract, which means synthetic LIBOR is irrelevant and it won't apply here. I can get the next slide up. Now, on the other hand, if we take a look at this example of how interest rates are sometimes defined in loan agreements, you'll see that the fallback is actually contained in the definition of LIBOR itself. So it says LIBOR means the applicable screen rate, or fallback, if no screen rate is available, then LIBOR means the percentage rate determined by the bank to be its cost of funds. So this is a different situation, because although that screen rate will cease to exist, the fallback itself will never get a chance to kick in, because, as I mentioned earlier, the effect of the incoming legislation is to change the actual definition of LIBOR in these contracts, so that any reference to LIBOR is just going to be treated as a reference to synthetic LIBOR. So the fallbacks are relevant in this case, and synthetic LIBOR will just apply. But that's just one example. And the wording of, so, you know, every contract will need to be considered on a case-to-case basis. If I can get the next slide up. So I just want to touch on the effect that all these changes might have on potential claims and whether we can still expect to see disputes arise over the coming months. And one sort of obvious point is that this legislation is a relatively blunt instrument, because on the first day of the new year, it's just going to change the interest rates payable under contracts that might be worth tens of millions of pounds. And there will be losers when that happens, which is probably going to provide pretty fertile ground for litigation. But Article 23FA of the Critical Benchmarks Bill, which I put on screen there, this tries to preserve any causes of action that exist prior to the date on which LIBOR is converted to synthetic. So whatever the actual impact of that will be is something that the courts need to determine. But the intent is to expressly preserve any pre-existing claims. So if borrowers lose out when the rates switch, we might see an uptick in speculative sort of mis-selling, misrep type claims. Certainly in the lead up, sort of the lead time between, you know, the announcement that LIBOR would cease back in 2017 and now, contracts were still being signed up which referenced LIBOR. So if appropriate fallbacks weren't incorporated into those contracts, there could be questions about the parties' intentions as to what would happen post 2021, because firms were well aware that this was happening. So some customers could feel as though they were misled about the economic consequences of entering into LIBOR-linked contracts, which were, you know, going to perhaps become useless. And of course, you know, for any agreements that reference the LIBOR tenors that are not being replaced by synthetic rates, if they don't have adequate fallback provisions and can't be transitioned to an alternative rate by the end of the year, there will probably be arguments about frustration and force majeure, etc. So we'll just have to wait and see. But that's all from me today. And with that, I'll pass you over to Ryan.
Thanks, Sean. Now for some fraud, hopefully to keep everyone's attention for the final segment of the webinar. The English court has lots of tools to assist the victims of fraud, and judges can apply those tools flexibly. This has allowed the court to adapt to challenges associated with internet fraud and most recently crypto fraud, which is the main focus of my section today. Key difficulties with these categories of fraud are, firstly, the ease with which wrongdoers can obscure their true identity. Also, that they can act from anywhere in the world and place the proceeds of the fraud in almost any, often multiple, jurisdictions. And they can do all of this incredibly quickly, often dissipating assets through multiple jurisdictions within hours or even minutes. So all of these factors pose serious obstacles to victims of fraud enforcing their legal rights in a meaningful way, essentially getting their money back, or at least the proceeds of whatever assets have been taken from them. So today I'm going to use a recent case in the English High Court, which will come up in the next slide, as a framework to explain many of the information gathering and enforcement powers available to the English court. Our context is crypto fraud, but it is important to remember that the tools I'll discuss are of wider application and have their origins actually in the pre-internet age, but they have been adapted and used flexibly to fit with the needs of contemporary cases. It's also worth noting that whilst few judicial systems are known for their speed, urgent matters, such as those involving fraud and dissipation of assets, like in this case, can be heard on an urgent basis, sometimes within hours, depending on the circumstances, and usually, and very importantly, without notice to any of the parties that might be associated with the fraud, because obviously tipping them off about what you're about to do could actually lead to the order that you're seeking being redundant or meaningless, because they will have known to move assets on or whatever where they might otherwise have been captured. So the case that I'm focusing on today is the rather long title on the slide, which I'll explain in more detail as we go along. But in short, it's a claim by Fetch.ai. They're a Cambridge-based artificial intelligence lab who are building a decentralized machine learning platform based on a distributed ledger. And that's direct from their website, and that's somewhat irrelevant, but that's who they are. The case is against persons unknown, i.e. anonymous fraudsters and their associated parties. And also parties to the case are Binance, which is probably quite well known to most of us, their cryptocurrency exchange. And that's the exchange through which the fraud was perpetrated. At the outset, it is important to note that Binance is not accused of wrongdoing. It's not being sued per se. It's a party to the proceedings, specifically to certain applications in the proceedings, because it's likely that it held information that could assist Fetch.ai. For the rest of the webinar, I'll say Fetch just for convenience, but assist Fetch in pursuing its claims and tracking down its assets, or at least the proceeds of sale of those assets by the fraudsters. So Binance is a respondent to the applications in the proceedings, so orders can be made requiring it to provide information that it holds without breaching any obligations of confidentiality to its clients. It's not uncommon for a third party to be willing, even eager, to assist in circumstances like this, but they often need a court order to make sure that they cannot be sued for breaching the confidentiality obligations they've got to their customers. So the court order gives them cover that they didn't have a choice in the matter and therefore couldn't be sued for breaching their duty of confidence or any contractual provisions applying in their consumer-facing documentation. Next slide, please. So we move on to the substance of the case study. It's a slightly more sophisticated fraud than others that involve maybe simply gaining access to a wallet and transferring out currency or whatever, or tricking an owner into transferring assets somewhere that they didn't intend. In this case, the unknown fraudsters managed to obtain access, seemingly using obviously confidential information, i.e. the key to the accounts at Binance. Those accounts contain various cryptocurrencies, USDT, BNB, BTC, and various others. The accounts were trading accounts that could buy and sell cryptocurrencies with counterparties who can be anonymous. When the fraudsters gained access to Fetch's accounts, they were able to trade the crypto assets in the accounts by adopting massive undervalues for the assets they traded. So it was a trade, but it was at the wrong price. So naturally, then there was very little left in the accounts of any value because a vanishingly small sum was paid for valuable assets. Naturally, the inference is that the third-party anonymous accounts that were buying the assets at a massive undervalue were all part of the same scheme. And it led to an aggregate loss for Fetch of over $2.6 million. So certainly a considerable loss in the space of, I think, a day. Probably much less than that even. Next slide, please. So the underlying legal claims brought by Fetch are not that important to the story, but just for the sake of completeness, they were breach of confidence, i.e. using that confidential information to gain access to the account, unjust enrichment, sort of speaks for itself, and equitable relief based on a constructive trust over misappropriated assets, i.e. when property is obtained by fraud, the fraudulent recipient is deemed to be holding it on trust for the victim of the fraud. The claims are for the return of Fetch's actual property, i.e. the crypto assets that were transferred away, or the identifiable proceeds thereof if they were onward transfer, and also damages against the wrongdoers. Obviously, the damage suffered can be more than the assets themselves, hence damages is also part of the remedies sought, and also assets may be so dissipated that neither they nor the proceeds can be easily identified, and then you pivot to damages, as it were, to adequately compensate a claimant. So now to the key problems. A case like this can have many problems, but my focus is on 3 for today's purposes. The identities of the fraudsters are unknown. Fetch did not know who did this. Secondly, the location, or more likely locations, of the fraudsters is unknown. Even if they could be identified, Fetch did not know where they are and consequently how to go after them. And thirdly, the location, again, more likely locations of the misappropriated assets themselves or the proceeds of selling them is unknown. I put location in inverted commas on the slide because this is not necessarily a point about geographic location. It's about identifying an account or an exchange or wallets or similar, which then might involve geographic considerations depending on the location of the exchange or the holder of a key to a relevant wallet or things like that. Next slide, please. So in order to pursue a legal case, Fetch needed to identify the relevant fraudsters and identify and freeze as many relevant assets as possible to avoid further dissipation. And that includes, if possible, their own crypto assets to the extent they're still intact in the hands of someone they can go after. In order to achieve that goal, they brought a set of applications heard in the High Court on the 15th of July. They were made without notice and in private, which is common when seeking to freeze assets and identify fraudsters. Again, it goes back to the tipping off point that I mentioned at the outset. I'll explain the orders in more detail shortly, but in summary, what was sought by Fetch is permission to serve the claim and orders against parties outside the jurisdiction and by alternative means. That's important because the location of the fraudsters was unknown. Given the subject matter of the dispute, some involvement of overseas jurisdictions is likely. And also one of the Binance entities themselves is based in the Cayman Islands. They also sought a proprietary injunction. That's to freeze the misappropriated assets themselves and or the traceable proceeds of those assets. This would prevent any party holding those things from dealing with them pending the outcome of the case. And also worldwide freezing order. This is similar to the proprietary injunction, but would apply to the fraudster's own assets and require delivery of information about their assets. That again links back to the point about damages I mentioned earlier. They also sought an order for disclosure of information and documents to assist the enforcement of the freezing order. That's quite common and it is effectively in a template form as part of the relevant rules. And interestingly, a further thing, and this brings us on to the Binance side of things, they sought a banker's trust order, which is named after the case in which it was first developed, rather than being a description of it, although it sort of is both. It's a type of disclosure order that can be made against financial institutions, usually banks, but in this case, Binance, where the claimant requires confidential information held by that party and documents to support a claim to trace assets that have been procured by fraud. So in this case, Binance managed the exchange and the accounts that were used to perpetrate the fraud. So there was a good chance they had at least some information that could assist. For example, identifying information regarding the owner of the anonymous account, perhaps that bought the assets from Fetch's account at the massive undervalue. Also potentially details of accounts where assets and their proceeds were onward transferred. Another type of order, again named after a famous case, or at least famous to lawyers, is the Norwich Pharmacal order. Again named, so it follows a case of quite a long time ago. It's a type of disclosure order, and it's made against third parties who are likely to have information or documents that are needed for a claimant to bring their case, including to help identify the correct defendants. They're wider in scope than bankers' trust orders. They can be against any third party, and they don't necessarily relate to tracing assets or fraud. For example, in another area of my own practice, defamation, also Nichola's practice, they can often be used against websites to obtain the details of users making defamatory posts online from an anonymous account, that type of thing. So they have a broader scope than bankers' trust, which is very focused on fraud and financial institutions. However, unlike bankers' trust orders, there's case law which suggests Norwich Pharmacal orders cannot be made outside the jurisdiction. So that's a point relevant in this case because of one of the Binance entities being incorporated in the Cayman Islands. So that's part of the reason why both are involved in this particular example. Next slide, please. So before the court made any orders, it had to consider some fundamental questions. Whether England and Wales is the right jurisdiction for the claim, whether English law applied, and if so, whether there's a serious issue to be tried that is available against the parties outside of the jurisdiction. So for current purposes, I'm going to park a discussion, which could be quite a long one, of jurisdictional gateways and the civil procedure rules and the intricacies of the Rome II regulation, now transposed into domestic law following Brexit. But those are all quite technical things. But in summary, the key factors that the court based its decision on those points are: it's now a fairly settled position that crypto assets are property under English law, which is an incredibly important thing in English law that isn't necessarily to be taken for granted in other jurisdictions. The cryptocurrencies in question should be regarded as property located in England. And that's because the owner, the first Fetch claimant, is domiciled in England. And that follows a decision of in an earlier case, Ion Science and Persons Unknown, from December last year. Thirdly, the damage occurred in this jurisdiction, and that's irrespective of where the the events giving rise to the damage occurred, but as far as the court's analysis goes, damage was suffered here. So those are the key factors that made the court comfortable to take jurisdiction and apply English law to the dispute. As many of you might be aware, the jurisdiction of the English court is largely based on service, i.e. can a defendant be served? Obviously anyone based here can be, but also for overseas defendants, there are criteria to be met to usually require permission from the court to serve certain defendants outside the jurisdiction, and that was obtained in this case. For the reasons mentioned, the court concluded England and Wales was the appropriate jurisdiction. An extra problem arises when a claimant does not know who to serve. This is the person's unknown element. Plus, it will usually take some time to validly effect service in an overseas jurisdiction, often involving mechanisms established by conventions and treaties and the like. And none of that is conducive to speedy and effective action in an urgent case. Therefore, in this case, the court used its power to order that the claimant can serve the defendants and the Binance respondent overseas by alternative means. An alternative means can be virtually anything the court says it is. And that's the need for speed in cases like this is why that was found to be appropriate. So it allowed Fetch to avoid the traditional mechanisms and the inherent delay involved in serving overseas defendants. Again, that's an example of the court being flexible in using its existing powers in order to ensure its orders achieve a real world outcome that is intended, and that orders just don't become redundant due to technicalities. Next slide, please. Thank you. So when it came to working out the application of the court's orders to the persons unknown, the court was not content to have them apply to a generic persons unknown category. The principal concern of the court in this case was to protect innocent third parties from having their assets frozen, just because somewhere down the line they have acquired crypto assets that once belonged to Fetch. There could well be good faith purchasers out there who have bought those assets for full value and had no idea that there was any issue with how they were acquired by the seller on up the chain of ownership in the past. So for that reason, the judge formulated three categories of persons unknown against whom different orders were made. Category A were those who were knowingly involved with the fraud, so the key protagonists. Category B, those who had received the assets without having paid full price. And then category C, which is probably the most important one that the judge was trying to deal with, is innocent receivers. Next slide, please. Then we turn to what actually happened. So the orders that were made, starting with those that were made against parties connected to the fraud. So this is excluding the Binance parties that I'll come to in a moment. A proprietary injunction was ordered. That's against all of the categories of persons unknown in relation to the misappropriated assets and their traceable proceeds. There was a limitation to protect the innocent receivers within the category C. So only those assets which people in that category knew or ought to reasonably have known belonged to Fetch, or at least did not belong to them, would be covered by the proprietary injunction. And separately, a worldwide freezing order, but only against the key protagonists, the people who would actually be sued for perpetrating the fraud. That's the part of the category A parties. Then turning to the orders made against Binance, I've explained the Bankers Trust order and the Norwich Pharmacal order. The Bankers Trust order was made for disclosure of confidential information to support the claim for assets. That was against both parties, both Binance parties. One sort of managed the exchange, one managed the accounts. And there was some uncertainty about which entities actually had the relevant information. And the Norwich Pharmacal order was made, but only against the UK party. And that's for the reason I've explained earlier. Norwich Pharmacal orders can't apply outside the jurisdiction. So that's how those orders were put together. I'm just conscious of time, so I'm skipping ahead slightly. So if I could just move the slide on to the next one, please. Yeah, so to conclude, this was a bit of a showcase of the powers of the English court to assist the victims of fraud, particularly in the time-critical and opaque circumstances of crypto fraud. The approach of the court was flexible, focused on practicality, and making sure that the orders had a real impact. And thankfully, it reflects a general trend that can be seen in decisions of the commercial court in particular in recent years. However, it's important to note that whilst we're lucky to have courts that would make orders that have extraterritorial reach, in particular worldwide freezing orders, which are very powerful, naturally the effect of those orders somewhat depends on the attitude of other jurisdictions to the enforcement of orders from the English court. Again, helpfully, by international standards, orders of the English court are among the most respected, but it would be wrong to suggest that they open every door. But also, helpfully, by virtue of the position of the City of London within the worldwide financial machinery, for want of a better way of putting it, there's an added benefit, because putting a succession of major banks, for example, on notice of a worldwide freezing order that might bite on assets that pass through them, or the owners of accounts that would be passing money through the institutions, can cause all sorts of trouble for individuals and institutions that either hold or have to pass money through this jurisdiction in some way. So that all adds to the bite of these powers that then the court can use. That said, undoubtedly better international cooperation on these matters would help everyone. But the English courts demonstrated as a leading jurisdiction for dealing robustly and flexibly with a wide range of sophisticated international frauds, including now those involving cryptocurrencies. And with that, I will pass back to Robin.
Thanks, Ryan. Thanks, Nichola and John. So I just want to raise a few questions that we've been given. In relation to LIBOR, it occurs to me that one of the potential arenas for disputes is not necessarily whether just a single lender and a borrower with a LIBOR sterling LIBOR loan. I think that can be covered off in most cases by the legislators and the regulators and what they have done of LIBOR throughout the global financial system. And the fact that you have, once you get into the very complex structured financial transactions, such as collateralized loan obligations, you suddenly have a lot more stakeholders involved who have different interests, who may not agree on what their solution is to the transition for LIBOR. And secondly, you may have complex realizations where you have whole pools of different loans, often from different lenders, which are going to have different LIBOR arrangements and clauses. And again, there are going to be different stakeholders involved. So following on from that, a question for Jean is, how does the UK's synthetic LIBOR solution interact with what's happening in other jurisdictions?
Well, it's still a bit up in the air, really. We are the home jurisdiction of LIBOR's administration, so there's no question that the UK has an important role to play in terms of minimising the disruption that LIBOR's death is going to have on global financial systems. And the FCA thinks that the use of synthetic LIBOR is going to flow through to other countries and be used globally in existing LIBOR-linked contracts around the world. But that would be subject to the legislative frameworks in those jurisdictions and how those frameworks deal with and permit legacy contracts to keep using synthetic rates. And some countries might not have such a broad opinion as the FCA about which contracts should be allowed to reference synthetic LIBOR. So we'll just have to sort of wait and see, really, is the answer.
Thank you. Thank you. I've got here a question for Ryan. To what extent do victims have to prove a solid case in order to obtain a freezing order?
Yeah, obviously, like in a situation like Fetch had, it was at the very outset of anything to do with the dispute. So certainly you weren't at the stage where you would be reaching trial, where there would be a judgment that actually would give a final determination. of all the issues, because firstly you would have had to serve the relevant defendants in order to get to that point and go through all the processes. So it's certainly not the level of you prove to a standard at trial, balance of probabilities in a civil dispute. So the way it would work in that situation is the court would have to be satisfied, firstly, that there's a serious issue to be tried in this jurisdiction. And that goes back to, in the Fetch example, crypto assets are property here, therefore one of the remedies could be a proprietary injunction to capture property, and the relevant claims can apply and are sort of good under English law and are good to the extent that they can be made against extraterritorial parties. So serious issue to be tried and a good arguable case. So there is a threshold, but it is not the sort of threshold that you would say you need by the time you actually get to trial and you thrash through all of the evidence. It's also worth mentioning as well that, as I said, in these cases, parties usually rock up to court without giving anyone any notice. And in the Fetch case, for fear of tipping off, and in the Fetch case, they did that and the hearing was heard in private, so no one could get wind of it before the orders were served on, say, Binance to try and freeze other accounts that might have been linked to the fraud, etc. So in those situations, what a party like Fetch would have to do is there's a duty of full and frank disclosure. So you actually have to sort of tell the court things that are against you. And it's very important you do that, because it can really undermine you if you haven't in the future. But it's another way that protects the unknown parties, just in case it's actually not a clear-cut fraud that it looks like. So the shorter answer is a good arguable case.
Thanks, Ryan. That's helpful. And Nichola, question for you. Apart from warranties and representations, which you mentioned, are there any other potential sources of claims in this sector, and what do you think would be the biggest source of claims?
Thanks, Robin. So I think that's interesting. I mean, it's maybe sort of a factual element where I can see sort of the biggest source of claims arising, and I think that's probably likely to be claims related to sort of environmental and social governance. I mean, as I mentioned in my presentation, next year, 45% of PE companies are intending to invest in green and sustainable companies. ESG issues are really high up on the list for PE companies, and actually many of their LPs are demanding that they deliver on investments which have these credentials. And in terms of their existing portfolio, many PE firms are actually required to report the ESG performance of their investments to the funds. So I think with this in mind, we may see an increasing sort of emphasis on warranties in relation to these issues. I think traditionally people have thought, warranties focus more on the financial things, but I think SPAs are going to be increasingly drafted with ESG matters in mind. So maybe more emphasis on what policies and procedures companies have in relation to financial crime, social matters, environmental and safety standards. So I think there's going to be a lot of sort of dispute around these issues because they're quite subjective as well. So, one person's idea of doing a good job of these things is very different to another person's. It's quite an intangible thing to measure in some respects. So I think back to the original question, I think claims relating to the the ESG credentials of portfolios companies is probably going to be an area for disputes, and whether they're breach of warranty claims, misrepresentation claims will remain to be seen. But I think that's an emerging area.
Thanks, Nichola. That's good. I think we've come to the end of our time, so we'll call a halt there. And sorry if we didn't get around to everybody's questions, but thank you for being with us this morning. And if you've got any further questions, do let us know.
Thank you.
Thank you.
Thank you.
Thank you.